Welcome to the 2020 Virtual National Institute on Healthcare Fraud, sponsored by the ABA Criminal Justice Section. This session is entitled False Claims Act Development. Moderating this session is Jonathan Diesenhaus. Jonathan is a partner at Hogan Lovells in Washington, D.C. Jonathan, you may proceed with the program.
Thank you, Donna. Good afternoon, everyone, and we hope that the next hour and a half will provide some healthy distraction from the troubles of the day. Sort of a strange day to be talking specifically about the False Claims Act, but maybe it'll be good for all our mutual mental health. So let me introduce our panelists, and then we will get into the law. And I can't tell how people are arrayed on the screen, so put your hand up when I call your name, I guess is the best way to do it. Jamie Yavelberg joins us from the Department of Justice. Jamie was appointed director of the fraud section in the Civil Division in May of this year. She's been handling False Claims Act and QTAM cases at the department for some 20 years. Jamie is really an expert, not just in jurisprudence and policy, which is now taking up a longer or more of her time, but also in hand-to-hand combat of investigations and litigation and in related disputes. So welcome, Jamie, and publicly congratulations, since we've only done it over Skype in these troubled times. Also with us is Kevin Lownds. Kevin, give us a wave. Okay. Kevin is managing attorney in the Massachusetts Medicaid Fraud Control Unit and within the Attorney General's office up there. He investigates and prosecutes healthcare fraud in state court and federal court. Kevin has been in the Medicaid Fraud Division since May of 2017 and has conducted investigations and led FCA cases of involving mental health clinics, home health providers, nursing homes, and clinical labs. Prior to his role, Kevin worked prior to this role, Kevin worked with a prominent firm in Washington, D.C. on white-collar criminal cases. Jinder Singh is joining us from a remote, undisclosed location and has been having some trouble with his camera, so you may not see Tejinder's face. Tejinder is a partner at Goldstein and Russell. He represents False Claims Act plaintiffs at the Supreme Court and in federal courts of appeals. He also helps to study the legal underpinnings of cases, get them off the ground, and help relators and their attorneys work through tricky, this is a quote, tricky legal and policy issues. Last but not least is Jack Bazie. Jack is now of counsel at Fried, Frank, Harris, Shriver, and Jacobson in DC. He was a partner there for over 30 years. Jack has been representing defendants in False Claims Act cases since 1981. He is the named author, co-author now with Doug Baruch of his book, Civil False Claims and QTAM Actions. That treatise was originally published in 1993 and is now in its 5th edition. Today, Jack does some work with defendants in cases. He lectures at numerous law schools, and in his spare time, he plays golf and enjoys his grandchildren. I'm honored to have this very experienced and esteemed panel with us, with me today, and I hope that you all enjoy what they have to say. Our housekeeping matter is that the chat box will be the place for you to present questions for us to work through. Our plan, since we have a moderated discussion arranged here and just given the technology, our plan is to receive your questions, but then hold them till the end and spend the last 15 minutes revisiting topics if necessary to discuss the questions or launching into new discussion based on the questions. But please do give us your questions. Interactive is good, and we welcome them. So can we have the next slide, please? So just to get everybody on the same page, we never know the exact experience level of folks in the crowd at the National Institute. So just want to lay a very quick basic foundation. The Federal Civil False Claims Act provides basically for a statutory tort. So it's always good to take a quick look at the words that we'll be dealing with and to think them through. Practitioners experienced practitioners tend to refer to the clauses as A1A, A1B. So if you have downloaded the materials and you have the statute handy, it might be a helpful decoder. This page might be a helpful decoder ring for when Jack talks. But focus of the statute is really on in A1A. It's anyone who knowingly causes to be presented or presents a false claim. The statute provides as well for liability for false statements that are used to get a false claim paid. That's B. And then particularly notable in the healthcare context is provision G, A1G, which applies when or imposes liability when someone makes, uses, or causes to be made or used a false record or statement that is material to an obligation to pay or transmit money or property to the government. That provision is the provision that nowadays creates overpayment exposure. And there hasn't been a lot of litigation under that yet. We'll talk more about obligation and overpayment in a second. Kevin, can you fill our guests in on the differences, similarities, how the federal statute impacts state enforcement?
I sure can. Thanks, Jonathan. So I will not, presume to speak for all states here, but I will do my best to sort of offer a state perspective during the course of the panel. So as many of you may know, there are many states that have their own version of the False Claims Act as well. There are more than 30 state FCAs. Some of those state FCAs largely mirror the federal FCA and some differ from it. So I wanted to highlight a few of the differences. Some state FCAs only apply to the Medicaid program or state healthcare programs. That's something that the state of Washington has. Some states don't have a qui tam feature, and so the actions are only authorized if brought by the government. That's like Missouri and Utah. Some states, like Wisconsin, had a state FCA and then repealed it, so it no longer exists. But one thing that I thought was useful to highlight is many of the state FCAs attempt to largely mirror the federal FCA for a specific reason. And what that reason is that under the Deficit Reduction Act of 2005, what I'll refer to as the DRA, a state gets a 10% bump in its recoveries if it is deemed compliant under the DRA by HHS OIG. And what that means, sort of in layman's terms, is if you're a state like Massachusetts, where the Medicaid recovery is ordinarily split 50-50 between the federal share and the state share of the Medicaid program, in an FCA recovery brought by the state would get a 60% recovery and the federal share would be 40%. And so under the DRA, a state FCA has to meet 4 requirements to be compliant. The requirements in brief are: 1, establish liability for false or fraudulent claims submission with respect to Medicaid spending. 2, contain provisions that are at least as effective in rewarding and facilitating PTAMs as those described in the FCA. 3, a seal requirement, contain a requirement for filing an action under seal for 60 days with review by the Attorney General. And then 4th, contain a civil penalty that is not less than the amount of the civil penalty authorized under the FCA. Now, last piece, the civil penalty has been an issue for some states because, as many of you know, DOJ adjusts the civil penalties for inflation. And as a result, some states, if they do not keep pace with those adjustments, have been found to be non-compliant under the DRA. So just as a sort of statistical matter, as of right now, 21 states, including Massachusetts, are DRA compliant. And the most recent state that was found to be DRA compliant was Hawaii, which was a fairly recent development. That's just a brief overview of the sort of state picture.
And so, make sure I'm not on mute. So short form, the state statutes present a lot of the same issues by design, effectively, because of the DRA incentive.
That's right. And Jonathan, the one thing I would add is that a lot of states, including Massachusetts, have sort of legal opinions in state court that indicate that FCA-related issues in state court or under the state FCA are sort of interpreted in conjunction with a much more robust federal FCA case law, right? And so, the developments in the federal FCA world tend to affect state FCAs sort of equally.
And because of the Medicaid overlap in most of those cases, many decisions under the state statutes are actually rendered by federal courts. So we all work together to understand and define terms in this statute. So Donna, if you can move forward to the next slide. Again, in the interest of brief tutorial so we can get to mixing it up, the statute or statutes, taking account of the state statutes, define some of the key terms, and then perhaps the most important has no statutory definition and relies on courts to interpret and apply common law principles. So we'll be talking today mostly about the application of the common law interpretations of false or fraudulent by courts. We'll be talking about materiality. And when we talk about it, we'll get into the definition, but there is a statutory definition of material in the False Claims Act at 3729B4. That's the natural tendency to influence test. And then the knowingly element, the knowing standard, we'll be talking about as well. The False Claims Act has statutory text that makes it clear, tripping over my tongue today, up too late. Statutory text that makes it clear that no proof of specific intent to defraud is required. Instead, the plaintiff, government, or relator need only prove actual knowledge, deliberate ignorance, or reckless disregard for the truth. The definition of claim is very broad, sweeps in a broad spectrum of the types of billings that are submitted in the healthcare context, pretty much without question. And as I mentioned, there is this term obligation. And while we won't be speaking much about it today as we drill into some of the recent developments, there hasn't been that much litigation under this provision yet. But the risk for a healthcare provider in particular, under the False Claims Act, expanded when in 2009 there was the term obligation was both added to the liability sections of the statute and then defined. as an established duty, blah, 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 arising from the retention of any overpayment. And so the program has gone on to adopt regulations defining an overpayment and trying to define a point in time when the obligation attaches. But the obligation to repay attaches, excuse me. But obligation and overpayment, overpayment wasn't clearly within the statute in the past, and as of 2009 it is. Creates a much more significant risk for providers, and for those of us who represent providers, we are often worrying about it. So those are the key terms, all appear in the statute, all appearing in the statute except for false and fraudulent. Donna, if we can switch to the next slide. We'll start with the other pressing issue of the day, COVID-19, the coronavirus, and felt it was important to talk somewhat hypothetically since litigation hasn't ripened in many contexts, and to be clear, we're not intending to put the government folks on the panel here in a position to need to talk about anything that's being investigated, either under seal or otherwise. But we did want to talk about conceptually how the False Claims Act could play a role in policing up the various different funds that are moving around the system as a result of COVID-19. And Kevin, why don't you start us off and on the topic?
Sure. So, I will do my best to be circumspect here without addressing sort of details of ongoing investigations. But what I would think in response to COVID-19 and the state response and the way in which a number of state AGs have already announced is, I think, an area of focus for the states in the COVID-19 response is likely to be long-term care facilities. Our office has already announced investigations into certain long-term care facilities. I know other state AGs have done the same. These facilities were, as I would assume all of you know, were obviously some of the hardest hit in the initial COVID waves. In Massachusetts, nearly 2/3 of the overall deaths from COVID-19 were at long-term care facilities. We have publicly announced investigations into some long-term care facilities for their handling of the pandemic. In fact, we recently announced criminal charges, not under the FCA, but under criminal neglect statutes against a former administrator and medical director of a veterans long-term care facility in Holyoke, Massachusetts. The AG has publicly stated that we have other investigations into long-term care facilities related to COVID-19 ongoing, and has also stated that those investigations could end up going civil or criminal. Just sort of to speak as to how, in very general terms, how we would approach that. I can speak for our unit and say that simply having a bad COVID outbreak would not mean a facility would be under investigation or liable under our theories, but we would look to whether there were infection control failures at the facility that would potentially give rise to liability. And in the event that we found something to that effect, I think there are a variety of legal theories under which a sort of infection control failure could be brought. And I do think that there is a category of claims under the FCA, under the worthless services theory, which is a basic doctrine in the long-term care facility context, in which the failure in the delivery of care of services renders those services so worthless that the submitting a claim for the services, in fact, is false and fraudulent. So I can see those potential theories. I mean, I'm certainly not commenting on whether we're using them or not, but it certainly seems like a thing that investigative bodies would consider as they look to address the long-term care facilities issues in the pandemic.
Thank you. Tejinder, from where you sit, what are you interested in terms of uh, uh, where the False Claims Act might be a useful tool, or, where are you hunting for clients?
So first of all, can people see me? I'm just curious. I was having a camera issue. Jonathan, can you see me?
Yes.
Awesome. That way you guys won't miss out. I was really worried for you. And it sounds like you can hear me too. That's great. Obviously you've got trillions of dollars going out the government's door, and that's going to raise the possibility that some significant amount of that money has been diverted wrongfully. And so there's any number of places that we can look to, and some of those things are on the slide. Stimulus fraud is, I think, a big one, and telehealth another. When you think about telehealth, the government has said to healthcare providers, we want you to reach patients wherever they are without forcing them to come in, potentially risking their health to do so. And so providing services remotely we're expecting, we know that there's been a big uptick in that. Even before the pandemic, telehealth was a huge topic. But it's also potentially a major fountainhead for fraud, because when you have telehealth services, now if you were inclined to engage in fraud, you aren't limited to just your neighborhood in terms of the folks who you could claim to provide services to, or provide worthless services to, or medically unnecessary services to. You can now try to provide them nationwide and build a government for that. And that, there's a really good example. It was a criminal case that involved back braces just being prescribed willy-nilly over telehealth, and then Medicare overpaying for those back braces. And there are similar claims that we think could very well become more prominent as this goes forward. And of course, there are now special rules as telehealth expands, and failure to comply with them could give rise to liability as well. That's a little bit more of a question mark in terms of whether FCA liability would be your first resort there. I think what we're really looking at is just the ways that telehealth has expanded the ability to provide medically unnecessary services, or services that weren't actually provided.
Thank you. Jamie, from your perspective, what are you interested in paying attention to?
Sure. Well, first, let me thank you, Jonathan, for inviting me to participate today, and my other panelists, and also to the conference for inviting me today. As you mentioned, I'm the director of the fraud section of the Civil Division at the Department of Justice, and I'm here to offer my perspectives based on my experiences. I'm very happy to share those today, but they don't necessarily represent the views of the department. With respect to COVID and potential COVID fraud, I think what I can share is a couple of big takeaways on this question. I think to echo Tejinder's point, a couple of Tejinder's points. First of all, the sheer size of these programs make them an area that we are very interested in. We're talking literally about trillions of dollars of government money being spent in far-reaching aspects of beyond healthcare to big business and industry. And so whenever you have that much money at stake, there is always the potential for fraud. In fact, there have already been some criminal cases reported involving fake cures for COVID, or illegally obtained PPP loans, or other kinds of fraudulent schemes. So we think there will be some, as there often are when there's this much money involved. I think the second important point to keep in mind here is that in creating and administering these programs, the government has been very mindful of the balance that it's striking here between taking into account that the emergency of the situation and the crisis. And for example, HHS had to be very nimble in finding ways to create maximum flexibility in getting people the healthcare that they needed. And so HHS expanded various telehealth options for providers and others to participate in, or relationships that providers could have with each other. And then likewise, in terms of the government programs that were stood up very quickly, there was a very pressing need to get the money out quickly to businesses that were suffering and the industries that were hit very hard by the pandemic, including the healthcare industry, which was really overwhelmed with a public health crisis and needed to have the financial supports in order to maintain the current level and standards of service that were provided. So on the one hand, the government needed to get the money out and wants to be very mindful of these flexibilities. On the other hand, the government has been worried about fraud from the inception of these programs, making sure that the money went where it was intended and making sure that the money was used as intended. And so the government does have guardrails in these programs. It's not like there are no rules. There is plenty of oversight by the government. First and foremost, Congress built in to the statute its own oversight authorities. It has regular reporting requirements that it has regarding the spending of these funds. But Congress also created a couple of new things. They created the Pandemic Response Accountability Committee, which is an organization of inspectors general that is dedicated specifically to ferreting out and keeping an eye on potential fraud involving stimulus funds. And there's also a new inspector general, a special inspector general for pandemic recovery, whose job is dedicated to keeping an eye on these monies and performing an audit and oversight function. And of course, the agencies themselves who are dispensing this money are being very thoughtful and keeping an eye on what is happening with the money that they have spent and the money that they have loaned that they are expecting to come back. I think the additional takeaway that I would note here is that because some of these are new programs or because some of the existing rules have been modified in light of the pandemic, it is very important for practitioners and providers to familiarize themselves with these changes. There may have been longstanding existing practices or rules that have been modified by agency action in the last couple of months. And it's important to keep in mind what those are and to research them. They will inform you about the government's views and may be different than what you're used to. I think lastly, the thing that I would underscore is that the government is always mindful about pursuing cases that are in the interest of justice. And that here, just because a company or an industry is struggling does not give it license to make false statements to the government. Everybody knows there's a crisis, but the important thing to keep in mind here is that when everybody plays by the rules, the money goes to the businesses and the companies that need the money and that are using the money for the proper purposes, and that we should all be combating fraud together. I think the last point is about the potential theories under the False Claims Act, but I think Jack was probably going to address them. I think before he even gets into it, I'm likely to agree with him that I think that a lot of the theories of liability that would arise as a result of pandemic funds, stimulus funds, or activity are really the same kinds of things we've seen in the past. So I don't think we're looking at novel cases. I think we're just looking at cases with potentially new overlays or new sources of funds. So with that, I guess, John, I could kick it over to Jack.
Oh, thank you. I just want to say also that my views expressed here are not only my own views, but should be the views of all right-thinking people. So I want everybody to understand that from the get-go. Look, the fact of the matter is, if you look back on the history of the False Claims Act, it has always followed the money. All right. It's a John Dillinger kind of situation. If there's money there, first of all, a lot of people are going to try to take advantage and sometimes disadvantage of the money and the source of the money. And shortly thereafter, we're going to have False Claims Act cases. It happened with the Vietnam War. It happened with the stimulus programs in 2008. It happened with real estate in the early 2000s. Wherever there is money, and especially large amounts of money over a short period of time, there are False Claims Act cases. And they'll be brought, some by the Justice Department, and I think many by qui tam relators. I agree with Jamie. There are no real new theories here. You know, when you look at telehealth, for example, it's going to be providing, you know, billing the government for unnecessary services. They're just you just bill people because you can, and you find their phone number and you make one call to them and then you bill them. That's a routine thing. People did it in warehouses. Now they're going to do it over the telephone. They're going to bill the government, and I hope they don't. Also, I find telehealth a pain in the ass, but that's my own view, because it just doesn't seem right, but it's better than going into a doctor's office. I think there are other programs. I don't know if they're just unique to the healthcare industry, where some of the certifications which are being required in order to either get or keep many of these PPP funds and other funds are pretty stringent. And I'm not sure I would sign them, but I think we are going to end up with some false certification cases out of this. But I think it's just going to be the normal run-of-the-mill theories under the False Claims Act. I don't think new theories will be created. And that's the law. Let me just ask one final point on an issue of policy, which is this. One of my fears coming out of these stimulus funds is that we're going to have a large uptick, especially in quitam cases, whether or not the government intervenes in them or not. I think there were a lot of people that are very angry. I mean, we only need to look at the Escobar case in terms of families who are upset about the care that their loved ones get, and they bring a quitam case. And I think that we are going to end up with a lot of False Claims Act cases against all kinds, but especially the long-term care facilities, but everyone else. I think it's going to be hard for many of those facilities to win those cases if they get to trial, because I think much of the public has already made their judgments about who acted properly and who didn't. And I would just urge the Justice Department to use what we're going to talk about later, which is the power to dismiss these cases under C2A. We had instances when we dealt with the mortgage fraud area back, which we were just resolving, where the government recovered billions of dollars. But what resulted, because in many ways, because of those false claims, that enforcement, was that many mortgage banks dropped out of the mortgage, the low and moderate income mortgage market. And those families couldn't get mortgages, resulting in an MOU between Justice and HUD in 2019 to get the program back on track. And I think we all have to be mindful of the problem that False Claims Act cases can cause to companies and facilities and institutions. And I hope that won't happen here. That's all I have to say.
Kevin, Jamie, Tejinder, any response? Nope. Okay. Well, we have a question that actually I'm going to ask the question now, since it ties closely into this, and then we'll move to the other. Question is, how does the government, state or federal, I would say, approach False Claims Act claims when the money at issue is grant funding rather than procurement or programmatic funding? I'll give a quick answer and then have folks weigh in. There are certifications on every grant application. There are requirements for reporting on how grant funds have been used, or the progress of, if it's a research grant, of the research, or otherwise. The government, there's sort of a well-plowed field of settlements and some litigation in that area, both intervened and declined cases on the federal side, where it may not be that a certification is false at the application stage, because the grantee intends to comply with the rules and regulations or the specific requirements of the grant, but that then over time, there's a lack of compliance and a failure to report and to update the agency funding the grant and to find out how to either come into compliance or whether to continue with the grant funds. So I think there is case law out there that falls in line with what I think with what Jack and Jamie were mentioning, that it's not really new theories. It may well be new types of representations in these applications for PPP, or I believe there's a separate program for hospitals that is like PPP. And so you're not able to step outside of the False Claims Act simply because the funds are grant funds with aspirational goals. They may not have specific deliverables like a contract or like a healthcare provider. But in my experience, the government's position has been that there are representations about how you're going to do something, even if it's a research grant with an uncertain end. How'd I do? Anybody? Did I get the question answered?
So I think, John, I would agree with that summary about grant fraud. I don't think that, I think the way the case is presented may make a difference as to whether or not it's a grant or a loan. But to the extent the question is, do grants fall outside the False Claims Act? The answer is no. And to the extent that the question was more directed conceptually at the idea of, well, the False Claims Act sort of sounds like invoices or claims being submitted for widgets being built. That would be a incorrect or overly narrow construction of what a claim is under the False Claims Act, which it clearly also includes when the money is being used for a governmental purpose. There is a definition of claim in the statute that makes it very clear that grants are essentially encompassed within, even if the money is dispensed immediately or dispensed periodically, that those could constitute claims within the meaning of the statute. So I think that would be sort of the legal side, John, to your more fact-based examples.
Mm-hmm.
John, I think there's one other thing that's important to talk about when you talk about grants. Grant applications normally require certifications of compliance with a large number of other statutes. I spent a lot of time working on FAA grants for airports, and they had to certify compliance with the Clean Water Act, the Clean Air Act, and a whole variety of other statutes. We're going to talk about it when we talk about materiality later. We're going to talk about Escobar, but those are difficult certifications, and people tend to just check the box and say they're in full compliance because there's only one box to check. I don't know how these new COVID-related grants are titled and the certifications that are required, but those certifications can be the basis of False Claims Act if those false certifications are material, which again we will talk about a little later in the program.
All good. And because of, as Jamie pointed out, the very broad definition of claim, you need to think about whether, like a subcontractor, a subgrantee who relies on a federal program grantee for funds is within the statute as well. So thank you for the question. Hope we answered it. And Donna, can you switch to the next slide, please? And for some reason, I can't see the slides. So somebody tell me if the slide's up. Oh, there. Is it the right slide?
Yeah.
Thank you. Tejinder is going to start us off on this topic, falsity and medical necessity. Over to you.
Sure. So this is a hot topic in recent cases. And the broad question is just how does a physician's opinion that services are reasonable and necessary become a false statement or basis for liability under the FCA? If you're familiar with the Medicare statute, you'll know that Medicare will only pay for services that are reasonable and necessary. And it's pretty well established that that's a real condition of payment, that if services are not reasonable and necessary, you aren't entitled to payment and your claims can be false. The term reasonable and necessary, though, isn't defined. There's a proposed rule that would seek to define it. But right now, the best guidance is in the Medicare Program Integrity Manual and in adjudications by the Department of Health and Human Services, where claims have been, decided whether they're going to be paid or not. And broadly speaking, there are 3 criteria. The service has to be safe and effective. It can't be experimental or investigational, and it has to be appropriate. And appropriate has some subcategories under it, but basically it means furnished in accordance with accepted standards of medical practice in an appropriate setting by qualified personnel, et cetera. Importantly, this standard for reimbursement is not the same as the standard for what constitutes medical malpractice. There are lots of things that doctors could do that the government will not pay for, and experimental treatments are probably the prime example of this. If you can convince your doctor to give you an experimental treatment for some bad illness, that might be good medicine. But that doesn't mean it's reasonable and necessary. And in this sense, Medicare's coverage is kind of like any other insurance company. One important fact is that under the Medicare rules, the onus is always on the party seeking government funds to establish the entitlement to funds. You have to have in hand, when you go to make the claim, a basis for thinking that the service actually is reasonable and necessary as CMS understands that term. And again, that's different from thinking, that this is good medicine. Sometimes you can have judgment calls, medical judgment calls that go into the necessity determination. So for example, there's a case that's on the slide, the Polikoff case. And this is about whether a particular surgical intervention was the right response to a particular heart condition. And the medical consensus basically said no. And this one doctor decided that the answer was yes. And the 10th Circuit held that that could be a false claim, because even though the doctor might be voicing his sort of sincerely held medical opinion, that did not bear on whether the services were reasonable and necessary as Medicare understands the term. And the court directed parties to look to the Medicare Program Integrity Manual to figure out what reasonable and necessary means in this context. There can also be different kinds of judgment calls. So there are criminal cases. You'll see the Paulus case cited there. And this is another case involving cardiologists, but this one was about diagnosis. You can get a stent normally if you have a certain amount of blockage in your blood vessels or collapsing in your blood vessels. And there were doctors who were putting in stents, and the allegation was that they were doing it even when there was nothing close to the required level of blockage. And the doctors responded, well, we're just kind of making a judgment call, reading the angiograms and, doing our best here. And the case basically held, no, that can be a false claim when what you're trying to do is in fact, put in stents where objectively you shouldn't be able to do it. This opens up a question of when can these judgments be false? And I think the government's position, which is also the plaintiff's position, and of course, I'd love for my government colleagues and Jack for the defense side to talk about this as well. The plaintiff's position is a claim is false whenever you submit a claim that's actually not eligible for reimbursement. So if you were to go and say, pay me for this surgery that I just did, but in fact, Medicare would not regard that service as reasonable and necessary, you've submitted a false claim. That doesn't necessarily mean you'll be liable under the False Claims Act, because you have to do it knowingly. And the word knowingly is defined in the statute to include basically every mental state north of negligence, right? Deliberate indifference to the truth or falsity, recklessness, those count, as does actual knowledge, but just negligence doesn't count. So if in good faith you submit a claim and it happens to be wrong, you're not going to be liable under the False Claims Act. But if you submit a claim that's not eligible for reimbursement and you do it with the requisite mental state, we think that's a culpable false claim. And really, if you think about it, that's no different from any other kind of claim, right? If you were to submit a claim, an invoice for, 10 computers, and you only supplied 9 computers. You submitted a false claim. And then the only question really is whether you did it knowingly. And if you did it knowingly, you can be held liable for at least the cost of that one computer. The same is true here. It's really just, is the claim eligible for reimbursement or isn't it, in accordance with the criteria that the government uses. And broadly speaking, that position tracks what you'll see in the case law about falsity. When you look at the cases that are up on the slide, most of them say that, well, there are Supreme Court cases that kind of guide this. There's the Escobar case, which has been alluded to already, where the Supreme Court said, rather than taking a circumscribed view of what it means for a claim to be false or fraudulent, you should enforce the scienter and materiality requirements to police the boundaries of liability. And that's pretty much exactly what I said you ought to do. There's also cases in other contexts about when opinions can be false, and they basically track what I just said, that an opinion that is wrong can also be fraudulent if it is done with the requisite mental state. That is, if the person offering the opinion doesn't sincerely believe it, hasn't done the homework to establish that the opinion is well-founded, or is aware of facts that would tend to contradict the opinion. And that kind of tracks what recklessness or deliberate ignorance is. So that's kind of the plaintiff side position, and you'll see that tracked out in the case law. One important wrinkle to keep track of as you look at the cases is that not all of the cases that you see are about the medical necessity requirement for Medicare. Some are about the hospice rules, which are a little bit different. So for hospice, the statute asks whether in a physician's clinical judgment, the patient has a terminal illness. And so in that case, where the statute is expressly asking for a criminal judgment, there have been some arguments made, and the 11th Circuit was fond of these arguments in the AseraCare decision, that imposes a little bit of a higher burden on the plaintiffs than it might in an ordinary medical necessity case. So there is a way potentially to distinguish those two lines of cases, but broadly speaking, they raise kind of the same themes, and there's a lot of overlap between the arguments folks will make.
So that's the basic, and Tejinder does a great job of making it out sound very simple, but the devil's really in the detail in these cases because of it's about proof and the relationship between a physician and the provider who acts on a physician's order. And so, Kevin, when you're mixing it up in these cases, how do you come at these theories? How do you see it play out?
Right. So yeah, I mean, I don't have that much to add to what Tejinder said, which I agree with. What I would say is in Massachusetts, specifically, and in state MFCUs generally, sorry, the acronym MFCU is Medicaid Fraud Control Units, lest any of you thought I was being, vulgar here. But in Massachusetts, we bring cases based on medical necessity a lot. And like the provisions that were cited, that Tejinder was citing with respect to Medicare, state Medicaid agencies typically have similar provisions that require that the services be medically necessary. So like in Massachusetts, for example, the providers have an all-provider manual that contains a medical necessity requirement. In addition, many of the individual services that providers render sort of have their own medical necessity requirements, some of which are sort of lay out what is and isn't medically necessary, which can sort of alleviate some of those problems of proof. But beyond that, our position is generally that services that are not medically necessary and are billed anyway constitute false claims. I think that the particular situation we're talking about, especially at the summary judgment stage, is one where a physician orders services, right? A plaintiff or government expert says they were unnecessary. A defense expert says they were necessary, or at least not unnecessary, and the situation plays out. It's not remotely uncommon for medical necessity to come down to a battle of the experts. And I don't think, speaking for me here, I don't think the mere fact that there's a fact issue out of the medical necessity as a result of the battle of the experts sort of entitles defendants in these cases to summary judgment. I think if the physician had a genuine belief in the necessity of the services, it seems to me that that's a fact issue that goes to the knowledge and scienter requirement, and less so to falsity. But so to sum it up, we have similar issues, and I largely agree with Tejinder.
I'm gonna hand it over to Jack, but the battle of the problem for me between separating scienter from falsity, knowledge from falsity in these cases, because what is being scrutinized as either true or false is an opinion. That ends up in a battle of the experts. They're conflated by the way that it gets articulated. And so it's a struggle in that litigation to get to parse out falsity versus scienter. Jack, you wanna tell us why this is such a murky area?
Well, to me, and as I've said many times, this to me is one of the most difficult areas in the False Claims Act. The False Claims Act, when it was passed in 1863, was designed for simple fraud, billing the government for gunpowder and supplying it with sawdust instead. I think all of us, any jury, any lawyer can determine what's gunpowder and what's sawdust pretty easily. That's not hard. But the problem is we are now taking falsity into one of the most difficult areas of what everyone faces, and we're facing it now especially. We're actually talking about the opinions regarding medical judgment, where a Medicare patient's entitlement to medical care, or in the case of hospice care, a dignified death, is at stake. And I guarantee you, I've said this many times, I'm the only Medicare beneficiary on this panel, all right? And I look at this a little differently than anyone else. Now look, we all know that there are going to be providers, doctors, hospice companies, anyone who are going to cheat and going to bill for medically unnecessary services. So the False Claims Act has to have a test as to how we determine these services to be medically unnecessary. Now, if you look at the three cases on the slide, and I'll start with Azericare. Azericare was an 11th Circuit case, and it involved, it was a post-trial case. In other words, this case went up to the 11th Circuit after a full trial, and then a JNOV granted by the district court, and then it went up to the 11th Circuit. Winter was, I believe, a motion to dismiss. So there was simply the quality of the pleading, and it ruled that the pleading was adequate, overruling the district court. Druding was a summary judgment case, where summary judgment was granted for the defendant, and it was reversed by the Third Circuit. And Druding, of course, is now up before the Supreme Court on a petition for cert. And Druding said very specifically, we have read the decision in Azericare and we believe it's wrong. Okay. Winter tried to say that Azericare was the same. They applied the Azericare test. I don't think they did, but at least they said that. But the Third Circuit said in Druding, we disagree. Now, I have to believe that, and we've talked about the battle of the experts, that the result in Azericare is directly related to the fact of the trial testimony. Because both in District Judge Brodre's district court decisions and in the Court of Appeals decision in the 11th Circuit, they both emphasized the testimony of the government expert. And I'll very quickly say what the government expert testified to. He made clear that his testimony was a reflection of his own clinical judgment based on his after-the-fact review of the supporting documentation he reviewed. He conceded that he was, quote, not in a position to discuss whether another physician was wrong about a particular patient's eligibility, nor could he say that his AeroCare's medical expert who disagreed with him was necessarily wrong. He never testified that no reasonable doctor could have concluded that the patients at issue. Even more damning to his testimony, he actually changed his position. And I emphasize this because both the district court decisions and the Court of Appeals decisions talk about this at some length. He actually had, at his deposition, he said that 2 or 3 patients were improperly given hospice services. And then when he testified at trial, he changed his opinion. And when in cross-examination, both by the defense lawyer and by the judge, he was asked why he could have different opinions. He said, and I quote, "I'm not the same physician in 2013 as I was in 2010. So in 3 years, he changed his mind." The courts couldn't get past that. I am absolutely convinced that they could not get past the fact that this expert said one thing was false in 2010 and it wasn't false in 2013. And he also said, I can't say that those other experts are wrong, which is what I think led to the 11th Circuit's definition of objective falsity, which was criticized in both Winter and Druding, that it conflated scienter with falsity. Because what it really said was, and there's a long definition, you can read it for yourself, but what it says is that objective falsity is where a certifying physician either fails to review the patient files or familiarize him with the condition, or where a plaintiff proves that a physician did not, in fact, subjectively believe that his patient was terminally ill at the time of the certification. They call that objective falsehood. The third way you can prove objective falsehood is by testifying that no reasonable physician could conclude that these services were medically necessary. And it is this issue of what is objective falsehood and whether that is a proper test for falsity under the False Claims Act that the defendants in Druding are now trying to get the Supreme Court to review. And as I said, there's a clear conflict in the circuits, and I think they might take it, okay? So if we're talking about this next year, we may be talking about this in the context of a Supreme Court decision. But in my view, okay, as a Medicare beneficiary, I believe the test has to be that no reasonable physician could conclude that these services were necessary. I can't find a way around a test other than that. That if the government or a qui tam relator can find an expert, which I think they had in Druding, that would swear that no reasonable physician could conclude that these services were medically necessary, then I think you may have a case. Anything short of that, I believe, simply could deprive Medicare beneficiaries of services that are medically necessary. And I don't think we can allow that. And I don't think the Medicare Act wants that to happen.
Okay. Jamie, I assume that you have a different view than Jack. How do you see the objective falsity standard as a necessary test or in application?
So where to start? So I just to sort of start with maybe with Jack's last point, I think that what is maybe a step that is missing maybe from Jack's analysis is that as Tejinder and Kevin pointed out, the federal statutes talk in terms of paying for what's reasonable and necessary in the opinion of the secretary. And then Medicare, by virtue of regulations, as well as lots of informal guidance, describes what it believes is reasonable and necessary for any type of condition. It doesn't speak to everything because it's nearly impossible to do that, but it does speak to a lot of things. And so, to use Tejinder's example, if Medicare, and I won't be able to state the rule exactly right, but if Medicare says we will pay for hospice care so long as your prognosis is that you have fewer than 6 months to live, then that's what's reasonable. That's what Medicare will pay for. That doesn't mean that a doctor who thinks that the patient should be on hospice, even if they have longer than 6 months to live, that the doctor can't put the patient on hospice, but Medicare won't pay for it unless they qualify under the definitions that Medicare has set out. So I think an important step between Jack's standard and what Tejinder described is that the concept of no reasonable physician standard is not grounded in the payment rules and is not grounded in what the government has said it will pay for, because it doesn't pay for everything. It pays for things that, based on its experience informed by many, it will decide to pay for. It's a very generous program, but it doesn't pay for everything. And so I think that is missing to some extent from that analysis. I would also say that the other piece that I think might be missing there is that juries regularly make determinations about these kinds of questions outside of the False Claims Act context. They do it in criminal cases, as Tejinder noted. They do it in medical malpractice cases. They do it in other kinds of matters where a jury is presented with differing views about the decisions that were made in the healthcare context. And courts let juries make those decisions. In fact, in the AseraCare decision, if I'm remembering correctly, the jury, in fact, found that the services were not medically necessary. And it was the judge, after the fact, that overturned the jury's decision. So we know juries are capable of making these decisions. And what I don't understand with I think I do understand it, but what I think is overlooked in the instinct to try to narrowly construe falsity in the concept of medical necessity cases is that worry. But if juries can do it in other contexts, I'm not sure why they can't do it here. And then I think also playing into that is the point that Tejinder made about opinions being false. There are many, many contexts and cases where opinions can be found false. It exists in the common law. It exists in other kinds of cases as well. Securities fraud is the prime example, and that's a very complex area of litigation as well, where an opinion can be a false statement. It can be false when the speaker doesn't actually hold the opinion, when they lack sufficient facts to state the opinion, or they imply the existence of something that's not true. And juries, again, are capable of making those kinds of decisions. So I don't think that just because this is an area that lends itself to differing views that may be subjective means that somehow a new standard of falsity or fraudulent needs to be imported for this unique kind of False Claims Act case. I don't think that makes a lot of sense from a jurisprudence standpoint. And I also don't think from a practical perspective it's necessary because, like I said, juries make these decisions all the time, and there's already kind of an overlay for doing that. What I think is driving the concerns that Jack fairly animates is the concern about being held liable under the False Claims Act. Have you knowingly submitted a false claim? And I think that, as the Supreme Court recognized in the Escobar case, which we keep alluding to, there is no need to take an overly narrow construction of what is false under the False Claims Act when you have the backstops of scienter and materiality. If the government can't show scienter, it cannot prove a False Claims Act violation. If the government can't show that the particular thing that was not complied with is material, it can't win a False Claims Act case. And so rather than narrowly construing the falsity term, which is what this medical necessity question is, the Supreme Court has already said that the way to ensure that where you fall on the spectrum of False Claims Act liability is with robust application of the materiality and scienter requirement, which I think gives Jonathan the perfect segue into the next topic that we're going to talk about, unless you wish to talk about this other one as well.
Nice.
John,
Yeah.
can I have 30 seconds?
You may.
Okay. Number one, Jamie, as I was listening you talking about when opinions are false, I was reading the 11th Circuit's definition of objective falsity, and they matched up almost perfectly. All right, that you really don't believe that, or in other words, what you were saying, what makes an opinion false, is exactly what I think the 11th Circuit was saying in objective falsity. Number two, I appreciate what you and Tejinder say about the enhancement of materiality and scienter, because there where you can have a weak falsity standard because we have these wonderful other things. The problem on opinion falsity, however, especially in the area of medical necessity, is that I don't think materiality really applies, believe it or not, because I think they're factually false cases. In other words, if you provide unnecessary services, that's we've always defined that before false certification got big as a classic. I mean, going back to Halper, okay, in 1986, that was a medically unnecessary services. We never even talked about materiality. It's simply false because they're not entitled to them. Now that has become more complicated, but it's still false. And scienter, I mean, I'm having a hard time figuring out how you can have something that is an opinion falsity. It's a false opinion, which is inherently subjective, and not also satisfy the scienter requirement of the False Claims Act. So when you rely on scienter and materiality in this area, I think it all comes back to falsity. It's all the same definition. So I don't think it provides any protection at all to defendants who are trying to act reasonably. I don't think materiality and scienter work at all. I think it all got to go back to the definition of falsity.
And so Jack, that was more than 30 seconds, and we want to talk about materiality in some length, and we want to save time for questions. And so I'm going to point out two things and then move on. And I had actually a whole set of good talking points. So if you want to talk to me about this later, call me. But I think there was a little bit of semantics I want to straighten out. Jamie said reasonable and necessary in the view of the secretary, and that's absolutely correct. The secretary can define reasonable and necessary, and in a lot of spaces does. I think what we're talking about, especially in the hospice cases, is that no reasonable physician would conclude that the secretary's criteria apply, right? So these medical necessity cases are most of the time about whether a physician has correctly determined, like in the hospice cases, that it is a terminal illness within the definition prescribed by the secretary. It is still inherently a judgment of the medical arts as to whether what's the prognosis, what's the diagnosis, and does the therapy or the item match up? That you need a physician for. And the reason I'm belaboring this or bringing this up is I think a lot of these cases lose track of the Johnson Compromise, lose track of the role the physician plays, because specifically the statute, the president, when it was enacted, said the program doesn't practice medicine, physicians do. That's why providers, they don't certify medical necessity. Hospitals, other hospices, they certify that they have an opinion and from a physician that it's reasonable and necessary in the circumstances within the prescribed definition, and that the medical record supports that conclusion. And so there's a it's not just the secretary's point of view that is critical in these cases, and that's what seems to be getting lost. Having a battle of experts second guess based on a medical record as opposed to seeing the patient is, in my mind, problematic. And so I'm going to move on. Don, if we can go to the next slide, and I'm going to then shut up and throw away all my great talking points and turn over to Jack for a shorter discussion of where we are these days on materiality.
All right, my job really here is to explain Escobar, and I'll try to do that. And remember that Escobar was a case involving an implied false certification. I always define an implied false certification as a false certification where the lawyer wasn't smart enough to find an express false certification. Because I think if you read the opinion in Escobar, there are plenty of express false certifications that could have been relied upon. So I skip over the express versus implied concept in Escobar. I know a lot of and some of these cases don't, they involve it. I find that boring because what I think the important part about Escobar is its definition of materiality. And the reason you have to have a materiality test is that every healthcare provider, every government contractor, every grantee, federal grantee, is subject to tens of thousands, if not hundreds of thousands of different laws and regulations that they're supposed to comply with. None of them do comply with all of those statutes and regulations. They almost cannot. No institution can comply with everything that its governing bodies say it's supposed to comply to. So we have to have a test as to what is so important, that if a defendant who submits a claim to the government violates that law, that claim becomes false, even though they provided the services that they were supposed to provide. They simply it becomes false. And the classic is the anti-kickback statute, right? For years and years and years, we argued about whether or not a violation of the anti-kickback made a claim false. And now it's really a matter of law to a great extent. But the question is, there are a lot of other laws, environmental laws and other laws that might be violated in the course of providing goods and services to the government. And when is that law so important that it's deemed material under the False Claims Act? Now, what is interesting, and Donna, if you could go to the next slide, the ones which is the definition of the False Claims Act. What is important is that if you read these four provisions, A, B, C, and G, you will only find materiality in subsection B and subsection G. The Escobar case involved subsection A, 3729 A1A, the classic presentation of a false or fraudulent claim for payment or approval to the government. Because it was based on a false certification, the Supreme Court said that false certification of compliance with law had to be material to the government's decision to pay. It had to be material. And the Supreme Court say, we note that the term material was not added by Congress in 2009 to subsection A, but we're going to impose upon subsection A, the false claim, a requirement of materiality when the case is based upon a false certification, theory of compliance, theory of liability. And they did it, and they defined it in certain ways. The Supreme Court said that the material has to be a rigorous and demanding materiality standard based on common law fraud, that materiality under the False Claims Act under A requires a misrepresentation of compliance with law that goes to the very essence of the bargain and is not minor or insubstantial, that the agency's designation of compliance with law or regulation as material or as a condition of payment is relevant but not dispositive as to whether a defendant's failure to comply with that law is in fact material, and that an agency's payment of the claim or similar claims or other action or inaction with knowledge of the violation is compelling evidence that the violation is not material, right? Now, importantly, the Supreme Court specifically said that we know the government argued that the new definition found in 3729B4 of materiality. We know what they said. We are not deciding whether that's the proper test because we have our own test. And I believe that the Supreme Court rejected that definition. And they rejected that definition because the Supreme Court very specifically said that the option of the government not to pay a claim doesn't make it material. It has got to be more than the government's simply option to pay. It's got to be more likely than not that the government won't pay that claim had they known of the violation. And this is a difficult concept. Most of these cases, Donna, if we can go back to the previous slide, most of these cases were cases that were originally brought pre-Escobar. In other words, the complaints were drafted and filed pre-Escobar. And many of them dealt with a situation where the pleading standard was not met. And the Supreme Court gave a pleading standard for materiality in Escobar. I think now relators and the government have understood what they have to plead, and we're into the next stage, which is a stage of proof. Because I think the standard on an Escobar is a factual proof standard. Now, not that motions to dismiss can't be brought. They can be. The Supreme Court said they could be. But I think this is an issue of fact. And it is an issue of fact that's going to be played out more and more. And I think this issue is going back to the Supreme Court. But it is that four-part test that the Supreme Court set forth in Escobar that is, to me, the most important.
Jack, let me jump in so that we don't have any questions yet. So we're going to keep talking. We have other subjects, but I want to make sure everybody gets a chance on materiality, especially our government friends who are representing the agencies and Tejinder, who are effectively representing the agencies that make these payment decisions on which the materiality standard focuses. So, Jamie, what do you think is wrong with Jack's position?
Well, I think I do not think Escobar said anything to endorse Jack's materiality standard. In fact, the way the case was briefed, neither the government nor the party, the defendant, nor the relator, nor any of the amici talked about materiality at all. The questions that were really presented and teed up in those cases really did derive from this implied certification theory, where on the defense side, the argument was in order for something to be a condition of payment, it needed to be expressly stated in a statute. And the government took the position, as Jack noted, that no, it didn't need to be expressly stated. The government just needed to be entitled to deny payment based on the violation of that particular requirement. The Supreme Court really did chart its own course here and put this overlay of materiality on how to evaluate these kinds of cases. So I do agree on that point. But I don't think that by the Supreme Court basically mimicking common law standards of materiality, that the court was sort of winking and nodding that somehow it was now adopting an outcome materiality test, which nobody has adopted in very many cases at all. And I think it is largely, it adopted a standard that is really quite consistent with the statutory standard under the False Claims Act They didn't explicitly say they were doing it. They didn't explicitly say they weren't doing it. But they did ground their materiality analysis in the common law, which I think is supported by the position that the government routinely takes in these cases about what materiality means. I think the other point to underscore from the description that Jack provided about what materiality means here, according to the Supreme Court, is it's actually a two-pronged question. There's objective and there's subjective materiality. An objective materiality may be whether a reasonable person would attach importance to the requirement in determining the government's choice of action. But there's also a prong that the defendant knew or had reason to know that the government would attach importance to the specific matter in determining its choice of action, regardless of whether a reasonable person would do so. So there are two ways to demonstrate materiality under the Supreme Court's test. I think that's sort of my initial reaction, John, to some of the materiality standard. There are a number of other topics to talk about, but maybe we should let some of the other panelists cover them in connection with the Escobar materiality test and its application today and the way it's playing out in the cases.
Yeah, well, and let me put in since I'm going to cut off my argument time at the end too. I'm going to ask sort of a loaded question, and I think Kevin's up next, but Tejinder, feel free to weigh in. I think the problem with the way materiality it is being raised or briefed or articulated with a focus on the tendency or Jamie's articulation of the subjective test that the government could have, knowing that the government could have denied payment, is that it writes out some language from the statute. The Supreme Court does say that among the relevant factors, not necessarily dispositive, is the payment decision, including with respect to the particular facts at issue. And what those of us on the defense side sort of seize on and at the same time struggle with is often these cases are investigated for a number of years. Qui-tam cases are investigated for a number of years. The government is on notice of something. Often payment doesn't stop. And particularly in a declined qui-tam, payment doesn't stop and the government doesn't try to get money back. And so even though there are multiple paths, as Jamie has articulated it, to how materiality can be shown, the relevance of what goes on in a qui-tam is clear in Escobar. Relevant, not necessarily dispositive, but relevant. And I think now that we're past the motion to dismiss, I wonder if you both are starting to deal with the practical implications of how to overcome the materiality or meet the materiality burden and overcome the trouble that we all make applying it in this qui-tam context. Kevin, I'll start with you.
Yeah, sure. So this comes up obviously in the Medicaid context. This comes up. This is a fairly straightforward. It's when you're talking about grants or something like that, the materiality inquiry I think is a little more complicated. Here, it's a more direct analysis, and in the Medicaid context, with respect to suspension or sort of stoppage of payment, particularly for state Medicaid agencies, there are regulatory requirements that are implicated in this sort of scheme and play out. And I will just note that Escobar was a Massachusetts case that was not intervened at the time it went up to the Supreme Court by our office, but involved similar regulations to an intervened case that we are in right now. And we're sort of dealing with this question of suspension at that level. And the relevant reg is 42 CFR 455.23. And what it requires is that when a Medicaid agency is aware of a credible allegation of fraud, they're required to suspend payment unless certain exceptions apply, right? And those exceptions can include law enforcement requests, but they also can include, and this is particularly relevant to the Escobar case itself, they can include access to care, right? So in the Medicaid context, there may be circumstances in which the government chooses not to suspend payment, not out of concern, not out of sort of disregard or lack of interest in the allegations, but because the allegations impact a provider network that could seriously disrupt patient care. And that was actually part of the sort of issue in Escobar ultimately. And at the time, Escobar went back to the First Circuit from the Supreme Court. MassHealth had not suspended payment to the provider at issue. And yet the court found that there are a variety of reasons. I mean, this was at the motion to dismiss stage. It found that because of the nature of the way MassHealth creates these as conditions of payment, that materiality was sufficiently pled. I think what ends up happening as a practical matter is that when MassHealth or a state Medicaid agency, the operative question and the question that plays out in discovery is, when did this allegation of fraud become credible, right? Or did it, right? And if it does, then which sort of exceptions to the applicable standard did the agency rely on if it chose not to suspend? One thing I would just note that can vary by state and creates a slightly different dynamic is that not all state FCAs authorize the Attorney General's office to share the allegations of a sealed qui tam with the affected agency. And so it may very well be that the sort of time period you're describing, Jonathan, where the allegations are sort of known to the government, they're known to the government, I guess, writ large, but they may not be known, depending on the way the state statute plays out, they may not be known to the specific agency, which creates a different problem with proof. And so it can play out in a different way at the state level. But anyway, I know we're running low on time, so I'll stop rambling and turn it over to Tejinder.
Still no questions to Jinder, so you want to?
Sure. So in these 2 minutes we have left, I think that it won't surprise anyone that I disagree with Jack's reading of the materiality standard. I think he's done kind of an artful job of putting words in the Supreme Court's mouth. And I think if you try to articulate Escobar the way he does in a case where I'm on the other side, I'll have a lot of fun. But the bigger point that I would make about it, just to add something new to the discussion, is that I think it really is important, and this builds off a point Jack made earlier about materiality in the medical necessity context. Materiality is potentially important in these certification cases, whether express or implied. And that's because the genesis of the Supreme Court's materiality requirement is defendants saying, oh no, you can't have implied certification cases because we violate like 1,000 laws and we can't be subject to False Claims Act liability for violating all these laws that we violate. That would be mean. And so the Supreme Court said, don't you worry, we're only going to allow you to be held liable for violations of the material laws, not for all the other laws you violate. And it's important to recognize that what materiality is designed to do is separate important legal requirements from ones that are not important. And it's kind of morphed into this much bigger debate about, what has the government done ever since the complaint was filed or since the allegations surfaced. And okay, we can have that discussion, but there are certain contexts, and factual falsity is the one that I would highlight, where materiality is like a non-starter for the defense side, I think, where basically the violations are material as a matter of law. And I think that is a point that shouldn't be overlooked.
Go ahead, Jack. I think Jack agreed.
I agree with that, Jinder. I think in most factual falsity cases, I mean, gunpowder versus sawdust. All right. I mean, it's pretty clear that if the government knew it was getting sawdust instead of gunpowder, it wouldn't pay the claim. I don't think there's a complicated materiality analysis to that. But when you start doing these factual falsity cases, for example, in the situations of Azericare and Druding and Winter, where you have these very complicated legal frameworks, and the question is, does the government really care about a violation here or there, or will they just go along with it? I think it gets more complicated.
Well, and in the healthcare context, that, and I think we have to wrap it up because but in a healthcare context in particular, where the rules and regulations provide a number of avenues short of a denial of payment for non-compliance, and where the government has other ways, especially state Medicaid inspection authorities, they have other ways to communicate that it matters to them and that you need to come into compliance, but here's a 60-day corrective action plan. We're going to be back, but keep providing services. It falls within the exception I think Kevin was talking about. But and then Tejinder, you can't write the words out of this Supreme Court opinion that Jack read. That's the other problem. So
they're quotes.
Hey, listen, I think we may be talking to ourselves at this point. I'm not sure. Donna, are you still there? Maybe not. Thank you, everyone.
Thank you, John. Appreciate it. Good talking with everybody.
If you're out there listening in streaming land, we had some topics to cover. There's some informational material then in the slides, and you can reach out to any of us if you have questions, or at least me and Jack and Tejinder. I don't want to volunteer our Kevin and Jamie for advice, but thank you to everybody. I enjoyed it, and it all worked out. So
thanks, guys.
Thank you.
see you soon.
Thank you.